Hello and welcome to our Ask a Pro, our commercial collections webinar today. My name is Chris Kimes. I'm the Director of Business Development and Marketing for the firm, and I will be your moderator today. Today I'm sharing the screen with Shauna Chambers, Director of Commercial Collections for the firm, and attorney Jim Kozilek, Managing Shareholder over our commercial business unit. Both Jim and Sean are out of our Columbus office, and I'm out of our Cleveland, Ohio office. Shauna comes to us with 19 years of experience in collections, the bulk of that on the commercial side. She also spent several years on our consumer side, focusing on probate work, and Jim has been with the firm for the past 15 years, exclusively on the commercial side, and has spent the last 7 managing our business unit dedicated to commercial collections. So welcome, Jim and Shauna. Thank you both for participating today and being our panelists. I'd like to set the stage for today. You will be muted. We definitely want to make sure that we keep any background noise down, so we've muted you for that. But it's a very interactive presentation today, so I really like to encourage everybody to ask questions throughout the course of the presentation. On the right-hand side of your screen, or left, depending how you have it set up, you should see a question feature. I'm encouraging you to ask questions throughout the presentation. I will be the only one who will see those. If I see that the question is something we're probably going to cover throughout the presentation, I'll hold off on that. But if it's something I should interrupt Shauna or Jim with, I will do that, and they are used to me doing that, so they're prepared for that. We should be done before noon today, and if we don't get to all the questions, we will definitely make sure that we get you those answers at a later date. What I will say is, in preparation for today, we took the top 10 questions that we receive when speaking to clients or prospects about engaging with us on commercial collections. It is by no means the full comprehensive list. That's why we asked you for specific questions that you might have upon registration. So we did receive several questions, and I want to thank you for that. I have them, and we will be covering them at the end of the presentation for sure. But again, if you have questions, please, please, please ask those throughout the course of the presentation. We are aware that some of you may have a documented recovery strategy today. Some of you may not have a documented recovery strategy today. We'll speak a little bit about that. Our recommendation always is to have a strategy or have a plan. We realize that the goal is never to have anyone fall into a default situation, but we realize that the reality is that it happens. So I believe that sets the stage pretty well for today. So without further ado, I think we should move on to our questions for today. And the first question is one of my favorite, and always one of the obvious ones, I guess, is at what point should I place a file into collections? Shauna, why don't you take a crack at that one?
Sure, absolutely, Chris, and good morning, everyone. I think that's a really important question, and you actually highlighted some of those points in your opening. The determine on when to place a file with Waltman, it can be determined on various factors, and to your point, the first question to ask is really, what does my current internal strategy look like? For a larger company, that may be an easier question to answer. You typically have a pretty well-defined process for handling and grading stages of delinquent accounts receivable. Typically, with a larger company, you've got an established process flow for handling those delinquency stages, maybe defined internal resources applied to those stages of recovery. Also partner with external recovery partners as well. So maybe you have that kind of in play. But as always, it's an opportunity to review and refine the processes, discover additional opportunities that may develop along the way. For the smaller companies and small businesses, this can really be a daunting task because you wear many different hats. Really look at your situation. Is your customer beyond their terms? Has your customer stopped communicating, responding? If they're a local customer, do they still appear to be operational? Have you attempted to contact them via email? Have you attempted to contact them, reach out to them via phone, or send your own special or customized demand letter, and you're still not getting a response? So in both those scenarios described, the time to place an account with Weltman is really determined upon your own established internal strategy. Our team has a vast experience in handling all the way from cure programs all the way up through charge-off recovery and even pre-existing or post-judgment programs. So, we're here to partner with our clients and potential clients to figure out where we can best supplement your strategy.
Wow, it's a lot to consider when making that determination. There's always indicators. Certainly, being non-responsive is an indicator, right? Thank you, Sean. I know that's always a challenging one. Which leads us kind of to the next question. And Jim, maybe you can answer the second question here. It's when considering placing a file to collections, whether it be pre-legal or for potential litigation, we're often asked, what documentation is required or what documentation might be preferred? Could you take that one, please?
Sure. And like Shauna said, welcome everyone. It's great to be here this morning, and we're very happy that you've joined us. As I said in our sort of online teaser, right? It's a very simple phrase that I use with people because it is easy to remember, and that is, it's not what you know, it's what you can show. And the knowing part has come from, unfortunately, several instances where I will be talking with a client or prospective client, and we'll talk about what's due and what documents they have, and they'll say, well, they know they owe it. And unfortunately, that is not provable, right? I mean, that is not something that you can use necessarily in a court of law to get your judgment, to be awarded a judgment. So you have to go a little bit farther than that, and you sort of start at the extreme, right? What you want to show is hopefully that there was an obligation between the parties. You as the creditor, them as the customer. The more in writing it is, the better, right? Now that can be, it can be a written contract. It could be a promissory note. It can be a credit application. It can be a purchase order. All those things that basically that can be produced in a court of law that says there was an obligation and it is outlined in this document or these documents. And then you have to show that that obligation wasn't honored. We shipped them X amount of widgets, or we provided X hour of services, or whatever your business is. The cost was Y amount of dollars, and they haven't paid. All right, so that shows, or they haven't paid in full. So you're showing that there was an obligation and that obligation has not been honored. And then this is the part where, honestly, it gets, this is probably the one where I think, and Shauna would probably agree with me, where we have some of the biggest issues is if you are asking for $10,000, what documents do you have to show that the that the obligation was $10,000. Now, again, it may be an invoice, it may be a purchase order, it might be several invoices or purchase orders. Where you start to get into, and we'll cover this in one of our further questions, is, you know, if your invoice is $10,000, but you place the claim with Weltman and you're asking for $10,500, the question that I would have would be, where did that extra $500 come from? Is it finance charges? Is it collection costs or attorney's fees? Is it you know, overdraft costs? There are all sorts of different things that can make it up. But one of the things that we look for when a claim is received by us and set up to go into our system is, does the amount that the client is telling us is what is owed match what's on the documents? Because that's what we want to do. Now, I've given you sort of the sort of, you know, the end of the road, right? When they haven't paid voluntarily and you have to go to court. And because I'm an attorney and a litigator, right? So that's what I do. Now, so you need it when you go to court. The question is will you do I need it right at the beginning? And the answer is not always, right? I mean, we get clients that place with us an account name and information and a balance, but there's no necessarily any documentation. The only problem with that is we can make written or telephonic demand based upon the information that you provide us. However, many times the customer, or in our world, the debtor, will say, well, I need you to send me the documentation. They want to see proof of it. Now, sometimes that's a delay tactic, and sometimes, you know, I didn't know about this. The person that was handling this is no longer here. You know, all those myriad of things that can come up. But so you have to be prepared to be able to provide that documentation even in an earlier stage. But that's basically, in a nutshell, you know, kind of what you need to place a claim.
Thanks, Jim. So it sounds like you really need to focus on, it's not what you know, it's what you can show. So having good, solid documentation is definitely something that you want to make sure you're striving towards at all times. Right. Thank
Absolutely.
you. Yeah, I appreciate that, and I really like that. It is easy to remember. The next thing we always get into is because, you know, we're talking commercial debts here today, right? So, Shauna, maybe you could take this because you're on the pre-legal side. Is a question we always get is, you know, are we able to discuss the obligation to somebody other than the signor when we are making an attempt to reach someone regarding their past due obligation? Shauna, can you take that one, please?
Sure, absolutely. And to your point, since we are dealing with commercial debt obligations, the very short answer to this is yes. In addition to the signor or personal guarantor, commercial debt obligations can be discussed with others, like other personal guarantors, of course. That's kind of a given. Attorney or counsel representing the liable parties, the business owner, any members of, you know, the LLC if it's structured in that manner, corporate officers of the business, businesses, accounts payable staff. Since commercial debts, you know, aren't afforded the same protections as consumer under FDCPA, you do have a broader, you know, opportunity to try to discuss and resolve the commercial debt obligations.
Oh, yeah, thank you. Yeah, we get that one quite a bit. So I want to jump back. We did have a question that I think others probably have as well. Jim, this is going to go back to you.
Sure.
And this has to do with documentation. And I'll read the question as it came through. So do the documents need to be originals with wet signature, or can they be reproductions of documents shared electronically?
Yeah, and in this day and age, that's an excellent question.
It really is.
In this day and age, you know, the sort of standard bearer was and it still is in many states. There is a mechanism called a cognovit note. I'm going to take it to the extreme, right? And a cognovit note is an obligation that basically says we don't have to, if you default on this, we don't have to give you notice, and we can file an action against you in court and have an attorney other than your attorney appear at court and file an answer admitting to the debt. It basically is another term for it is a confession of judgment. In those situations, the court really does want to see the sort of blue ink signature. Now that is sort of the extreme. There are probably some courts that would allow you to get away with. In fact, I was looking at one today where it was an electronic signature. As you can, so when we go with photocopies or ones that are, you have the original application or the original contract and you scan it and you store it electronically, which many businesses do that now. The only issue with that is one, you want to make sure you've got a really clear copy, right? Because I know that some of the fine print is fairly small. And I've had to ask many clients to send us a blank copy of a contract just so we can point out to the court where we're asking for, interest or attorney's fees or collection costs, or that it needs to be filed in this particular court or this particular forum. So the other issue is that if you're going to store them electronically or you're going to take the signature electronically, you have to be prepared to be able to have someone with knowledge as to how your documents are kept, how long you keep them, if they are scanned, what's done with the original, who has access to the database, all those types of things that basically support that this document is authentic and this person that is testifying either in person or by way of an affidavit is competent to testify from personal knowledge or the knowledge of the business processes that this is an authentic document. And it is, the catch line is in an affidavit is that it is a true and accurate copy, right? So that this is what it is and it's accurate.
Thank you, Jim. So if I could ask a sub question to that, and I just want to thank everyone for all the questions that are coming in. You probably see me peering down here. We had several about this. So I just want to ask this question for the non-attorney guy here, right? Is it the exception versus the rule that you need a wet signature?
I would say it's the exception.
Okay.
I would say in this day and age, I would say it's the exception.
Okay, thank you so much. I have another question coming through here. So I'm going to look at this. I think it has to do with documentation. So just bear with me, everyone. And again, thank you for all the questions. And I knew documentation would get a lot of them. Okay, so with web applications, if it shows that they have accepted the terms box or check that off, if it shows that in the email used will help in the recovery. So basically, I think the question is, if it shows that they've checked the terms and conditions box, is that something that will help in the overall recovery on an obligation, Jim?
Yeah, as far as proving it, but not necessarily. I wouldn't say that is like the be all end all, right? I mean, so what you want to do is they have checked the terms and conditions, right? And if you can show that, that means that they are bound to the terms and conditions. The question is well, what do the terms and the conditions say, right? So, but the other thing is this: if that is part and parcel to. For instance, I know when I do things online, it will not allow me to get to another screen unless I accept the terms, right? And so one is you're accepting the terms and conditions for the creditor to ship the product, right? Or to give you the license or whatever it is that you do. So if you have that in conjunction with, acceptance of the product or acceptance of the service or acceptance and use of the license, then you can basically use those two elements together to show that there was an obligation.
Great. Thank you, Jim. And again, thanks for the questions. They're coming in pretty good here. I've got a couple written down that I'll say at the end here. Sticking with Jim, this is question 4. This is one that we get all the time. And this is a tough one to answer in a minute or two here, Jim, but can I ask for attorney fees and or collection costs in the event of failure to pay or need to place the account with a third party?
Yeah,
Jim,
and
please,
that is a question that we get that all the time. And
yeah,
and I was trying to sort of give you a little bit of a segue on my last one about the terms and conditions, right? So what do the terms and conditions say? So if you have a written agreement between creditor and customer, and it says, if you don't meet your obligations, then we can pursue you for the amounts owed. We can pursue you for interest at 1.5% per month or the highest allowable by law. We can pursue you for collection costs and attorney's fees. What courts want to show, what they want to see is they want to see an agreement between the parties that they agree to those terms. So the best form that it is in the written contract. And I say that because there will be times where there's no written agreement, okay? There's a credit application, but the credit application doesn't address finance charges or collection costs and or other things like that, right? But the invoice says at the bottom of it that you agree to pay it within net 30 days. And any payment not made within net 30 days will accrue a finance charge of 1.5% for interest. If that invoice is signed, then I would make that argument that you're entitled to it. If it's not, just being able to prove that they received the goods or received the services is probably not going to be enough, because think about it this way, right? I mean, basically what you're saying is, we agreed to do business with you in this way. And then only upon receipt of the goods and or services do you start throwing other terms at me. And if there's no proof that they agreed to that, what courts like to see is they want to see an agreement beforehand, right? Now, the other issue is this. You can have it in your contract, you can have it in your credit application, you can have it in your invoice, you can have it on all three, right? And you can ask for it. But one, you may not get it. Meaning, I say this with great deference to the court. The judge is not always right, but the judge is always the judge. So if the judge says that you're not going to get it, the question that you have to ask yourself, and I'll give you another example, is this. You got $10,000. You were asking for $500 in collection costs, or you were asking for 18% per annum in interest, in finance charges, and the court does, and that equals $750. You've got a judgment for $10,000. Your remedy, if you don't get that additional $750, is to basically go to the appellate court and say the trial court judge got it wrong. That to me is not an amount that is not worth pursuing. Okay. Now let me give you another example. Another example is that you place the claim for $10,000, but it calls for collection costs and attorney's fees, and that $750 is still there, right? And so we have it set up in our system that you owe $10,750, and the debtor pays $10,000. and they say, I'm not going to pay the $750. The question back to you is, do you want to file a lawsuit for $750 when you've already got $10,000? And again, you look at the economics of it and you say, that's really not worth it. Yes, we're not getting back after payment and the loss of money over time, the value of that money 6 months ago versus now, it still probably is not worth it. Now, if your numbers are not 750, but 7,500 or 75,000, that's another story, but it really comes down to economics on that.
Right. And Jim, if I could say, we have several of our clients are on today's call, and I thank them, and they're asking some questions here. This is clearly one of those topics that you or one of your other attorneys would help coach somebody through. Is that fair?
Oh yeah, absolutely.
Okay.
Absolutely.
All right. Thank you. I hope that answers some of the questions that are coming through. I think some of this is case by case as well, and state by state, and certainly knowing the landscape of the area. It clearly, you know, our folks do. But thank you so much for that, Jim. And we're going to talk about interest here in a minute, so I'll let you get some water. And we're going to pick on you for a second, Shauna. Shauna, this is a question that we get all the time about personal guarantees. Is it helpful, you know, or how important is it, if you will, to have a personal guarantee on commercial accounts?
Well, Chris, that's a really good question. Again, another short answer, right? It is certainly helpful to have a personal guarantee on commercial accounts. By doing that, it broadens the creditor's opportunity for repayment in case the business just is unable to meet its credit obligations. That personal guarantee provides an additional layer of protection as well. And also it provides another avenue of recovery and an additional pool of assets to pursue in cases where, you know, you may have to pursue this via suit and post-judgment collection efforts. But in cases where you don't have a personal guarantee, all is not necessarily lost. You still can pursue the business entity that's liable for incurring the debt. But an important item to consider is the type of entity that owes you the debt, right? Is it truly a separate liable entity like an LLC or a corporation? Ask yourself, could it be a DBA? I can't tell you the number of countless times, and Jim can probably attest to this, that we receive a referral and they place it as, you know, Joe's Tire Shop, and come to find out through our initial review of the file, which is part of our onboarding process for new business, is that we look at that to confirm that is a liable separate entity to pursue. It could truly be a sole proprietorship person doing business as the company that, you know, you're trying to go after. So you definitely want to take a look at that and have a working knowledge of, you know, what type of business structure that you're dealing with.
Right.
And let me add on to that really quick, Chris. I
Sure.
mean, you know, since I like to throw out the word know, right? It's not what you know, it's what you can show. Simple phrase, know your customer. Know your customer. We know that a lot of times sales are generated by people on the street. We represent a lot of service industries, a lot of goods suppliers, and we know that those leads, those sales are generated by salespeople on the street. That's the business model, and that's fine. What we find, and nobody does, right? Everyone is looking at getting product into the field, filling the space, right? They're not thinking when they are at this shop, signing up this customer for these goods and or services, that in 2 years, they may have to try to figure out, they might have to try to remember that day that they were at that shop, signing up that customer for goods and or services. So knowing your customer is very important. one very simple way of doing that: get a copy of a check. And we're going to talk about this in a little bit as well. Get a copy of a check. Keep a copy of a check. That gives you a wealth of information. It tells you who your customer is because it's written right there on the check. Because not all McDonald's are owned by McDonald's Corporation. There are so many franchises out there that you really need to know who your customer is. Getting a check from them and keeping a check on file is extremely important. It also tells you where they bank in the event that they don't pay and that they do not heed our efforts to collect the debt prior to litigation, and we have to go to litigation and we get a judgment. If we are allowed to file a bank attachment in that state, having that bank information, incredibly important.
Thank you. Hey, so we're getting a little bit of a backup on some questions, which is exactly what I hoped would happen. So again, thank you, everybody. Jim, this one's going to go to you, and it has to do with, is there a benefit or a drawback to having the business owners as co-borrowers instead of guarantors?
You know, that really is sort of a semantics. I think, you know, it depends. A co-borrower, typically the terms will say that, you know, you can pursue the guarantor jointly and severally, right? Okay, so let me give you a scenario. You have an obligation with the business, and you have husband and wife, owners of the business, and they're your guarantors. You know, typically the terms of the obligation says that, you know, we don't necessarily have to get 1/3 from each, right? We can get it all from Mr. Smith or Mrs. Smith or XYZ Corporation. It doesn't matter. And a lot of times there will be terms in there that say we don't have to, you know, we don't have to give you a notice of a default. I think a lot of it would really just have to depend on the verbiage that you are using. But I don't necessarily see the thing with guarantees is sometimes, and again, it's what your obligation says. What words are you using? Is what are they guaranteeing? Are they guaranteeing the debt? Are they guaranteeing that are they guaranteeing the debt? Are they guaranteeing performance? Are they guaranteeing something else, right? So it really, it depends. If they're a co-borrower, then they're probably going to be a party to all of the terms in the agreement, and you don't have to worry about whether or not there's any limitations on their guarantee or an amount that they're limited on.
Right. That might be one we'll get back to. The individual asked, it might be something that's in their agreement or something we could help coach through. So we can touch back on that one. Jim, I'm going to stick with you for the sixth question here because you touched on it already. It has to do with interest. So, you know, can I ask for a specified amount of interest if the obligation is not paid? And before you answer that one, if anyone out there is asking for interest, you know, just kind of, we'll do an unofficial poll. Just kind of let us know that you are or aren't, just out of curiosity. This is something I think we saw a lot more several years ago than I think we're seeing more recently. But Jim, go ahead and answer that one.
Yeah, again, it depends on what the terms say, right? And I see more times than not, to your point, Chris, more times than not, there will be some sort of provision in there that in the agreement or the credit application that says if you don't pay your, you know, our terms are net 5, net 10, net 30. And if you don't pay it on there, then we are going to add a, you know, a finance charge. Yeah, late fee. Or a finance charge, or it will accrue interest. You know, one of the nice things, Shauna sort of mentioned it earlier about the difference between commercial and consumer debt. You know, on the consumer side, there's always an issue about whether or not the interest is usurious, right, or usury. And there are caps on that types of things. But there's really not on the commercial side. Now, that being said, what I typically see is I would say more times than not, what I'm seeing is 18% per annum, 1.5% per month, right? I've seen 1%, I've seen up to 2%, but I really haven't seen, I rarely see anything above that. And most typically I see 1.5% per annum or 18%, or 1.5 per month or 18% per annum. But again, having the terms in the contract that are clearly agreed to by the parties is always your strongest argument. You can always ask for it. We certainly do. Again, providing us that information. The debt was due this day. Interest started to accrue on this day. This is what it is accruing at, and we can put that into our system. And so our system matches your system, and we can ask for it.
Got it. Yeah, thanks for that one, Jim. And we have a COVID related question out here that I'm going to park for a minute. We'll get to that for sure. Just so the person who asked that knows that we'll get to that. So, Sean, I've been leaving you out, so I apologize. We're going to come back to you with this one because we get this question all the time. Question 7 is what happens if if the debtor, the adverse party, the customer, what happens if they file bankruptcy? And I think this is going to go back to question 5 that had to do with the PGs a little bit. So go ahead, please.
Sure, absolutely. So the customer files bankruptcy. First step, obviously, is to cease activity on the accounts. Really important to adhere to the automatic stay. Follow your internal established protocol for handling those bankruptcy notices. On the Weltman side, if your account is placed with us, you absolutely can leave it with us. We have a dedicated bankruptcy department that handles all aspects of bankruptcy-related matters. And what's really nice about, using us, obviously, is that we have that dedicated bankruptcy department. We have the seamless transition. So we can work in tandem with our bankruptcy partners to make sure that all aspects of recovery on that commercial obligation remain visible. So in essence, you could have the bankruptcy area plugged in, handling and addressing the bankruptcy matters, and the commercial department also plugged in where applicable to ensure that we don't have to worry about losing complete visibility in trying to recover the obligation.
So if I'm hearing you right, make sure you stop collection activity right away and don't sit on it because there's timelines and things out there. The last thing you want to do, and I know when I meet with some of our prospects and clients who wear multiple hats, sometimes they're putting those to the side because they're not exactly sure what to do. And I guess the recommendation for today is act quickly because you don't want to miss out on the timeline. Shauna, that's going to roll into the next question that we get also. There are unfortunate situations where somebody, the guarantor passes away. What should I be doing there?
Same approach in this respect. It's not a single approach. It's a multifaceted approach when you're dealing with commercial. And timeliness is important as it relates to probate as well as bankruptcy. You have very short timelines in some states for filing a proof of claim in a probate estate, some as short as 3 months. In other states, it can go on for quite some time. There are over 3,500 probate courts across the United States, and 50 different sets of probate laws. And I really want to drill down on the importance of when you're dealing with commercial. So if you have a personal guarantor or cosigner that passes away, you really don't want to silo yourself in kind of making a decision one way or the other, correct? You want to make sure that you are covering all facets of recovery. And what's also nice about, working for Weltman is that we have that one-stop shop. We have that dedicated probate recovery group that we partner with on a daily basis. So in essence, in one respect, my commercial team may be pursuing the business and living guarantor or cosigner, and at the same time, we're able to engage our probate department to really take a look at, doing an estate search and filing a proof of claim and securing the creditor's interest in that estate. So it's timeliness, it's recognizing it.
Sure.
We have scrubs in place. If you don't have a scrub or a methodology for finding, out if your guarantor or obligor has passed away, I suggest that you look into that. Obviously, we're here to assist and consult and develop a strategy or work with you to develop a strategy that works for you as well.
Thank you, Shauna, for that, and I appreciate it. So we have several questions in the queue here. So I'm going to get to those. We have about, let's say, 15 to 18 minutes left here. Jim, I'm going to combine two questions that we normally get here for you. Is it 9 and 10? Is it a problem if I have an arbitration provision in my agreement, and the other one is a venue provision in my agreement? You want to give us a high level on those two, please?
Right, and those do go together, right? So the first is an arbitration provision, and an arbitration provision goes to the forum, right? The parties have agreed not to go to court. They've agreed to go to private contract dispute resolution, which is what arbitration is. And I would say you don't have a problem with it if you want to arbitrate, right? What I find is that, and I'll tell you, I've been doing arbitrations I've been with Weltman for 15 years, but I'm coming up on my 20th year of practicing law. And the very first case, the day after I was sworn in, was an arbitration hearing. So I've been doing them from day one. And I can tell you that if your client wants to arbitrate, okay, or if our client wants to arbitrate, or the client wants to arbitrate, it's a really simple arbitration provision. The parties agree to arbitrate, right? And then you list the forum, AAA, JAMS, whatever. All right. What I see is that if you are trying, and this goes with some of the larger institutional lenders, right? If you are trying to avoid class action lawsuits, if you are trying to avoid counterclaims, things like that, that you really don't necessarily want to arbitrate, then that can be a much more complex arbitration provision. But it really is faster. It really is more economically feasible as a whole. And it really, if there's an arbitration provision in the contract, then the creditor or our guests as creditors need to be prepared to arbitrate. Same thing with a venue, right? It says that all lawsuits are going to be filed in Columbus, Ohio. Okay, and that is extremely, they're very enforceable. Arbitration provisions are also very enforceable. But the question becomes is, where's your customer, right? Because I do have clients that have venue provisions that say Columbus, Ohio. And I'm more than happy to institute legal proceedings on their behalf under the venue provision in Columbus, Ohio. The problem is that if your customer is in Detroit, Michigan, or Chicago, Illinois, or Minneapolis, St. Paul, Minnesota, right? You end up creating another layer if the other one of the great. I will tell you that when someone is faced with having to defend a lawsuit out of state, the chances of a default go up. All right. So in my sort of my own sort of opinion based on my experience, if you have a venue provision and your customer's out of state, there's a really good chance you're going to get a default. The problem is you're not going to be able to really collect on that judgment out of Columbus, Ohio, if the debtor is in Detroit, Michigan, and they have no presence in the state of Ohio, or they don't bank at, a big bank, a big national bank. So you're going to have to take that judgment and you're going to have to move it to that state and begin collections. And that adds another step. It adds more time, and it adds more costs. So they're good, but they're not perfect.
Got it. Thank you, Jim. I'm going to proceed to a couple of the questions that were asked via the registration. One is, and Jim, you might want to take a quick stab at this one. What rights does a creditor have if an account charges off and we find out that the business is sold?
Right. And we get that a lot. So that's a tough one in the sense that you have an obligation with the business, and the debt goes into default, and you're trying to call on them, and they're saying, well, no, we're the new owner. The question really becomes, when were the goods and services provided? Were they provided prior to the sale or after the sale? If they were provided after the sale, then you can make an argument that new owner or old owner, the new owner is obligated for those purchases or services or goods received after the sale, right? They may be contractually obligated based upon the bill of sale between the new owner and the old owner. It just depends on what it says. I've seen some where they say that the new owner is taking over all the contracts, or it will say that the new owner is taking over contract A, B, C, and D. And
right.
If it's not A, B, C, or D, they're not liable for it, right? It depends. The problem comes up, Chris, getting that information, getting the new owner to tell you with any clarity and factual basis, this is when we bought, right? And or giving you the sale paperwork, right? Trying to get it from the new owner and the old owner, they have a tendency to just sort of pass it back and forth. And sometimes you are left with the choice of having to file a lawsuit against the new owner and the old owner at the same time, saying somebody owes us some money. We're not sure if it's the new owner or the old owner, if it's all of it or part of it, but one of these two parties owes us money.
Thank you. Yeah, that was a great question. Here's another one. How do you work with a business who tells you that they cannot pay due to an interrupted revenue stream on their part?
Shauna, you want to take that, or you want me to?
Sure, go ahead, Jim.
Okay, thanks.
We're on a roll.
Yeah, right. It's something that I say when I'm sort of giving maybe a 30-second elevator pitch to a prospective client is, you have to ask yourself when your customer is not your customer anymore, right?
Correct.
Okay. So rule number one: don't throw good money after bad. If they can't pay for their current obligation, then you really have to go through some extra due diligence to decide whether or not you want to give them any more product or any more services, right? Because you could just be throwing good money after bad. The other thing is, but you want to work with them. Business relationships are about business relationships. They've been a customer of ours for 20 years. Their dad started the business. It's now their son. We know that, and that's important. That is how businesses are built in this country. So you do want to try to work with them. You're not legally obligated to, but it could be one of those things where it is, hey, if I don't get the product, then I can't generate any revenue. And if I don't generate any revenue, I'm not going to be able to pay you. Right. So it's a case by case basis. I think what you want to do is you want to be very leery about providing any goods and services without any payment on those new goods and services, as well as a percentage of the old debt as well. And I want to throw something out here because it's really, really important. And this is not on any of our materials. For all the creditors out there and all of our guests here today, there's a very important piece of legislation that is being circulated right now. It is called Senate Bill 3565. And it was drafted by Sherrod Brown from Ohio, but it also was co-sponsored by Elizabeth Warren, Cory Booker, Bernie Sanders, and it is proposing during the COVID crisis to stop debt collection. Okay. Now, I've spoken with someone from Sherrod Brown's office, and they have said, no, you can still collect debt. You just can't file lawsuits. But that's not what the bill says. I'm sorry, but that's not what the bill says. And I say that because it basically says that small businesses cannot collect from other small businesses. They can't collect from individuals. They can't collect from other small businesses. The only people that they can collect are big businesses. And it really, it's an alarming bill. So for our guests out there, please go on Google, look up Senate Bill 3565. It is floating around. In our industry, in the creditors' rights industry, we're concerned that this is going to get shoehorned onto some sort of relief package that is going to prohibit debt collection for the term of the pandemic plus 180 days. So please look it up.
So I'm going to jump to this COVID question in a second here, Jim, but there was some questions here about advice. So if you'd like to learn more about some of the things that our attorneys are writing blogs and things about, you can always go to weltman.com and sign up to be on our mailing lists to get our advisories and whatnot. So it's just at weltman.com for the person who asked that. Jim, the question that we did is, our company has provided assistance for those affected by COVID-19. We have deferred several payments, and now these accounts are past due again. How would you approach these accounts when collecting after we've already provided some assistance? And if you could give a quick one on that, that'd be great.
Sure. Again, and a lot of times we follow the lead of our clients, and they tell us whether or not they want us to sort of soft pedal it or not, right? But I think at that point, you need to find out. If they are open and they are operating, and they are generating revenue, then I think you need to push for some sort of payment, right? You need to start getting it caught up, because you, as a small business, medium-sized business, big business, you have bills to pay too. You have employees to pay. You have product to build or services to provide. All of that has a cost. And so making sure that your level of default does not reach an unacceptable level is important.
So Jim and Shauna, the question that came in, and that was perfect, Jim. It's, can you talk to us a little bit about the value of a payment plan? What does a payment plan do for me? You touched on a little bit earlier too about banking information and whatnot. So is there any high level quick answer to that one?
Yeah, I'll just jump right in and take this. So, and I'm going to take Shauna's part too, right? Again, having payment information is incredible, but let's say you don't, right? So from Shauna's perspective, which is the sort of pre-litigation part, okay, you don't want to string these things out too long. You want to try to have, I would say on average, from what I've seen as far as client standards, it's usually, somewhere between like 90 and 180 days max, right? And the smaller the debt, the shorter the window is going to be. Our clients in general don't like to go beyond 90 days. Now, it gets a little bit different for me if I filed a litigation, I filed a legal action, and we want to get it resolved. That's when you start looking at the cost, right? How quickly can I get in money? How much longer do I have to deal with this contested litigation or this litigation that's been filed? But how do I also protect this from the client's perspective, getting that money, right? So from my perspective, you can go a little bit longer as long as you have it written down in an agreement that is filed with the court, right? We do what's called an agreed judgment entry, where we basically put the terms down and we say, as long as they do this, we won't we won't attempt to execute on this judgment. But
Yeah.
and as long as they do, then they can pay this amount over these terms.
It's a great tool.
Yeah, it is. Now, you can get it in writing prior to filing suit. One of the advantages to that is you're not necessarily going to get a legal pleading. But if you put together an agreement that says that we agree that this debt for account 1, 2, 3, 4, 5 is going to be paid this amount over this period of time, and they default on that, you can file a legal action on the breach of that separate agreement, that written agreement to repay it. It is no longer about the widgets that you provided or the food or the uniforms. It's about that piece of paper that outlines the terms, and it makes it a lot easier.
Right, thanks. And we're going to be wrapping up here in a second. To get back to some of the folks that are asking, can they have set up a deeper dive conversation with us? Absolutely. If you want to send it over to me in the notes here, I'd be happy to get a hold of you individually. We're probably not going to get to some of the questions regarding payment to settlements that came through, but I do want to ask Shauna real quickly. This came through. I've placed a file with one company, whether it be an agency, I'm assuming, or maybe a law firm, and they were unsuccessful placing that. Am I allowed to place that with somebody else? I mean, I know the answer, but we'll let you take that one.
Sure, absolutely. And obviously we're talking about second placements all the way up to, we've seen in the commercial space, tertiary, probably the latest stage that I've seen in my experience. But if I can kind of hop back, one thing I wanted to kind of add to the last question is in the pre-legal arena too, a couple things in determining payment plans is based upon the type of business and the balance. We have some clients that, have smaller balances placed where a payment plan would make sense versus maybe some larger balances that are placed, but they're maybe not a litigation program. So I kind of wanted to tag that on to the end of
yeah, no, thank you. So, Shauna, we just have a minute. We're going to cover these takeaways in just a second, but someone asked this question really quickly. What options are available? Okay, basically the question is, I've obtained a judgment, but I'm still not collecting. What options are available if I have a judgment, and is this something that Weltman handles?
Absolutely. We have dedicated pre-existing judgment collection programs. So that's in our wheelhouse. We have dedicated post-judgment collectors. We can domesticate judgments to local jurisdiction and start post-judgment recovery. So we're very well versed and very experienced in that realm.
Well, listen, I just want to thank everyone for today. I want to be mindful of everybody's time. It means a great deal that everyone took the time to jump on today. Obviously, this is a big topic, right? And, the question regarding the COVID situation, that's real, it's out there, and it's just going to continue to be out there. I think some 5 takeaways I would just say. It's not what you know, it's what you can show. Thank you, Jim, for that one. Make sure you have a solid agreement with your customers. Pay attention to the deadlines on bankruptcy and probate accounts. You have additional options when you have cosigns or personal guarantees. So if you can get them, get them. It's just going to help you. And obtaining the judgment is a great thing. However, you still need to collect. Thanks for everybody. For those who asked, are we going to do more of these? The answer is yes. Your feedback's very, very important. So if you'd like to shoot us a note, that would be great. We'd appreciate it. Hopefully you found this to be a benefit. We can't thank you enough for your time. Again, to register to get on our email lists for webinars, blogs and such is at weltman.com. Shauna, Jim, thank you so much. Really appreciate it. This was fun. And to everyone out there, stay safe and healthy. Thank you so much.
Thank you.
Thanks, everyone.